presiding.
Please be seated if you have a seat. Otherwise, you're standing. As most of you can tell, we're doing a little modification to the courthouse, and particularly this room. Sorry for any inconvenience. Ms. Plambeck, welcome back. Mr. Paulson, welcome back. Ms. Simpson, welcome back. As promised, we'll go on the record in 22 CF 6-7. The court must admonish, ladies and gentlemen, that these are serious matters. We're here for the rendering of a verdict, and during these proceedings there will be no outburst of any kind from either side. If I hear it, law enforcement is present and you will be removed from my courtroom. Is that clear? Most people are nodding. Okay. This court has heard 4 full days of evidence and arguments on a 12-count trial information filed by the state of Illinois against Karen Plambeck. The court heard testimony from both the state and the defense, reviewed hundreds of exhibits, hours of video, and is now prepared to render a verdict in this matter. In rendering this verdict, the court has considered the statute 510 ILCS 70/3.02A, subsection A. The text most pertinent to our purposes here today reads as follows. No person may intentionally commit an act that causes a companion animal to suffer serious injury or death. Having heard this evidence, the testimony, and having had an opportunity to gauge and weigh the credibility of the witnesses presenting testimony, the court has also disregarded certain information that it had gleaned from evidence that was presented in this court, as promised, because it was inadmissible, either due to a lack of relevance, prejudicial nature as it was presented. It was, some of it was speculative or otherwise prohibited from being considered by me, and I have disregarded that information in coming to my decision. The court also asked the attorneys during closing arguments about their interpretation regarding the applicable law in this particular case. I asked pointed questions and considered those arguments. The court also considered the following cases interpreting the applicable law in this, including People v. Kirkpatrick, 2020, Illinois, Appellate 5th, 160422, 2020, which directed this court to apply its common sense. I always do, but it was very instructive. Second case that I found instructive was People v. Lee, 2015, Illinois, Appellate 1st, 132059, 2015 decision. Based upon the evidence, which was substantial, some would call somewhat overwhelming, the court finds that Karen Plambeck undertook a duty of care for nearly 200 dogs but the court only considers the dogs identified in the trial information on the 12 counts that I was to consider, Ms. Plambeck. First dog, the one that was euthanized, the dead dog. Merle, Chunky, the ligature injury dog, the matted dog 167 with hot spots, Galveston, Beauty, Elena, Sweetie, Buddy, Poppy, and Sir Lancelot. By her own admission and the testimony of the witnesses involved in this case, Karen Plambeck was a breeder of collies for years. The court finds that these dogs were companion animals and meets the element within the statute. The court further finds that Karen Plambeck undertook the duty to care for these companion animals. No one foisted these dogs upon her. She sought them out or agreed to nurture and care for these animals, which was a conscious choice. Because of Karen Plambeck's choice, she was duty-bound to provide and care for these dogs. Testimony revealed that this was not the duty of others. It was hers alone, and despite evidence that others would help care for the dogs from time to time, at her specific request, she was the caretaker and she was responsible for these animals. In her care, these dogs have suffered to the point of causing death and serious injury. Just as Karen Plambeck had a duty to protect, nurture, and care for these companion animals, the court has a duty to hold her accountable for a conscious choice not to care for these animals. That choice was an overt act in consciously failing to provide care when a duty was owed. This court finds that a duty existed, an intentional act was committed in failing to fulfill a duty of care, and finds as follows. As to count 1, the court finds Ms. Plambeck guilty. Count 2, guilty. Count 3, guilty. Count 4, not guilty. Count 5, guilty. Count 6, guilty. Count 7, guilty. Count 8, guilty. Count 9, guilty. Count 10, guilty. Count 11, guilty. Count 12, guilty. The evidence of guilt in this case is overwhelming. The court found that the state's witnesses were all credible and their testimony was corroborated by other witness testimony and by the entered exhibits or both. Defense witnesses at times expressed some bias or lack of knowledge as to the facts on the date of the alleged offenses. The court does find the testimony of Kurt Plambeck and Casey Plambeck credible. The court would like to thank all the witnesses in this case for your honesty, integrity, and testimony before this honorable court. This court, having rendered its verdict, will now order a pre-sentence investigation. That investigation will take place and this matter will be set for sentencing no later than 90 days from today's date, at which time, Ms. Plambeck, we will have a hearing in mitigation and aggravation, and I will hear arguments again as to what your punishment or accountability should be in this case. The state will argue the other side, the factors in aggravation. Any other outstanding cases that are associated or trailing along with this matter will be set for status at this time. The lawyers in the case at this point will come forward. Choose a date for the sentencing, and I would expect a full afternoon or a full morning.
Yes.
And once that is determined with the circuit court, you will come back and find me in chambers. That is all for now.
June 4th at 1 o'clock, and you would have till 4 o'clock.
Can we do a Monday versus a Tuesday?
The problem is I work on Monday, so I would not be able to give you a full ask.
Can we do a morning on Monday?
How many hours? All morning, want it? I would say
Half day.
yeah, so I can give you June 10th, starting at 9 till noon.
That works.
Is that right?
Can I?
You just wanna fill in?
Yes, I can. June 10th.
Yes, and just right on there, 9 AM to noon. And I will.
He said we should go.
He said to come get it, I thought.
Okay, see if he wants.
I'll see.
Said to come back and find him in chambers.
Take this back to him in chambers.
No, he said to come get him, is what he said, so if you just wanna bring it up
Yeah.
here.
All rise, please.
Court's now back in session. Please be seated if you have a seat.
He's right.
Court has been presented in 22 CF 67, a sentencing date of June 10th, 2024, 9 a.m. We've blocked out an entire morning. Is that correct, Ms. Simpson?
Yes, Your Honor.
Mr. Paulson, does that work for you?
Yes, Judge.
Court services is ordered to prepare pre-sentence investigation prior to that date. Ms. Plambeck, you are ordered to cooperate with court services in getting that completed. That report tells me the good things about you, your criminal past, your work history, your social history, your family history, those kind of things. So it's important that you cooperate with court services because they work for this court. You understand, Ms. Plambeck?
Yes, Your Honor.
Very well.
Your Honor, I would ask that the defendant be admonished of failure to appear to the sentencing and that it could proceed without her.
The defendant has been admonished by this court numerous times of what happens if you fail to appear. A warrant could issue, or we could have a sentencing hearing in your absence. That's called a sentencing in absentia. Do you understand that, Ms. Plambeck?
Yes, Your Honor.
You've been here every other time, so I expect you to be here. And I expect you to coordinate with your attorney to present your best case at sentencing. Anything further, Ms. Simpson?
Nothing from the state.
Mr. Paulson?
No, Judge.
Very well, that'll conclude these matters. Thank you all for coming. Goodbye.
Please gather
There was one case this morning that did not get handled. How'd you get out of your t-shirt and work clothes so fast?
She's,
You're done for the day.
okay.
You get cleaned up, man. How them boys do?
Good. Big.
Hey, listen,
Oh, money now.
this is the deal. Now, Owen's big old,
Yeah.
and I'm in the elevator with him. And, yeah, I'm joking, as I always do. You know, I like people, and he seems to be one of the good ones. So I smack him on the shoulder. It's like hitting a concrete block. He's a solid kid.
Yeah.
He was up this morning at 5:30 because he's been playing basketball. There's a group that do it at the high school on Wednesday and Friday.
Oh, wow.
So he plays
Yes.
from 6 to about 7.
Oh. Now, he's not
Yes.
doing, is he doing esports at, okay.
Right
But
now?
he's
That's
figuring
interesting.
out that 18 months of doing nothing.
Okay, thank you, bud.